So next we move on to another very important topic, that is interstate river disputes. Now before we move on to the issue as such, we look into the constitutional provisions in regard to the interstate river disputes. It is in Article 262 that there is a mention about the interstate river. Now what it says is that the Parliament may by law provide for the adjudication of any dispute or complaint with respect to the use, distribution or control of the waters of or in any interstate river or river valley. So that is being mentioned in the Constitution. And this particular provision excludes the jurisdiction of all courts, that includes the Supreme Court. Now as per this article, the Parliament brought in a particular act that is called as the Interstate River Water Disputes Act in 1956. But even after years, when you look at the interstate river disputes, you can say that the act has failed to address the various issues. Now, so what are the shortcomings of this particular act? The first thing is that it has said that a separate tribunal will be established for each interstate river water dispute. So an ad hoc tribunal will be formed. And then there have been delays that had been happening, that is in regard to the no time limit for the adjudication. It has been said that around 3 of the verdict out of the 8 different tribunals, only 3 have been given up the final verdict that was being accepted by the different states. So that is an issue. And even in cases of Kaveri as well as Ravi Bias, the tribunal has been formed more than 20 years and it has not yet given the verdict. So there is no time limit for the adjudication. And then second, it is in regard to the no time limit for the publishing the report of the tribunal. So earlier what was the requirement was that the tribunal used to give its final verdict, and that need to be notified by the government to bring it into effect. So there was a delay that was happening. In one of the tribunals what happened, the delay was of 3 years. So that led to the non-implementation or delay in the implementation of the verdict of the tribunal. And then you have the vacancies again resulting in the delays. And then there was also no age limit for the chairperson as well as other members. So that and all led to the delay in the giving up of the various verdict in regard to the interstate river disputes. So now we look into what the current affairs is all about. It's in regard to the Interstate River Water Disputes Amendment Bill of 2017. Now this is formed, or this has been proposed with an objective of streamlining the adjudication of the interstate river disputes and making the present legal and institutional architecture more robust. So in what it actually, or in brief, what it aims at making is, it aims at adjudicate or speedy adjudication of the interstate river water disputes. Now what are other provisions? Now first, it is in regard to the single standing tribunal with the multiple benches, and this will be replacing the different tribunals that were formed for different interstate river water disputes as per the 1956 Act. So you have single standing tribunal. And then what about the member composition? It mainly consists of the chairperson, you have the vice chairperson as well as not more than 6 members. And this chairperson will be either the former Supreme Court or High Court judge, and the others will be as per their expertise. So what is the tenure? It is that the chairperson will be having a tenure of 5 years or not less than 70 years. And then you have 70 years of age, and then you have the vice chairperson as well as not more than 6 members having the tenure only till that adjudication of a particular interstate river dispute is being done. Okay, so that is, you have the 5 years or you have the 70 years of age limit, so whichever is less, and then you have the vice chairperson as well as others having a tenure that is coterminous with the adjudication of the interstate river dispute. Okay, now what is the time period? Now time period is, the maximum time period for the adjudication is 4.5 years. That was not there in the previous act. And then you have the decision of the tribunal is considered to be final and binding to all the states concerned. So these are the provisions. Now you have other provisions. The bill also provides for assessors to provide the technical support to the tribunal. And then you have the Dispute Resolution Committee. Now what is this Dispute Resolution Committee? Now this is a committee that will be formed by the government, and that will be aiming for the amicable resolution of the interstate river disputes before it is being taken to the tribunal. So it is a before stage of the case being taken to the tribunal. So DRC is being also provided in the bill, and then it also provides for a transparent data collection system at the national level. So it also provides for a data collection. So that prevents or that avoids the cases where the hasty collection of data is being made at a time a tribunal forms in and it adjudicates certain interstate river disputes. Okay, so these are the main provisions in regard to the bill. In short, you can say that it's a single tribunal and its member composition you need to be aware of it, and then you have the time period of 4.5 years, and then you have the decision is final as well as binding, and then you have the presence of assessors to provide the technical expertise, and then you have the dispute resolution committee to provide to ensure that to look into the chances of resolving the issue before it is taken to the tribunal, and you have the data collection system which will be maintained by the expert group. So these are the main things in regard or the provisions as per the Interstate River Water Dispute Amendment Bill of 2017. Now what are the advantages of this particular bill? The first thing is that you have the time limit that will ensure a speedier adjudication of the cases, and then that is a time limit of 4.5 years, and then you have the presence of the agency to collect the data that will ensure that that avoids the hasty collection of data, and also the cases where the authenticity of the data is being asked by the other states. And then you have the awards to be automatically notified by the tribunal. Earlier I have already mentioned that there was a delay of 3 years happening between the verdict that is given by the tribunal as well as its authentifying or the notification by the government. So now that delay is being avoided and it will be automatically notified by the tribunal itself. So these are the advantages. But there are negatives. Now what are the negatives? Negatives is that there always lies a chance of appeal to the Supreme Court. So what happens? The objective of speedier adjudication is never being kept. That is, and the Supreme Court has also explicitly mentioned that it has the right to look into the appeals of the verdict or the verdicts given by the tribunal as under the Article 136. So it always keeps in a chance of appeal to the Supreme Court, and that has led to the challenge how the speedier adjudication will be ensured. And then again you have the tribunal giving its verdict and it goes to the Supreme Court to the appeal, and even the Supreme Court gives the verdict, but then there is a non-compliance by the states. So the bill has not yet been made clear as to what will happen if this particular compliance is not being ensured. That is, if the states are not complying by the verdict, what will be its impact? So that is what final as well as binding really means is not ensured, and also what will happen in the case of the non-compliance by the states of the verdicts. And then for that you don't have an implementing mechanism, so there's a lack of implementing mechanism, and also there has also been criticism that the states were not being properly consulted while the drafting of this particular amendment bill. So these are the negatives. That is, the first thing, always there's a chance of appeal to the Supreme Court, and then what actually the final and the binding nature means, and then you have the lack of implementing mechanism, and then you have the states not being consulted. So these are the negatives. And so what is the way forward? Now of course the way forward lies in addressing these particular negatives. So with respect to the appeal to the Supreme Court, we need to ensure that proper clarity is being brought in which all cases the appeal can be made. And also the government makes it clear that what happens if the states are not complying by the verdicts that is given by the tribunal, and then there needs to be an implementing mechanism that looks into that the order is being properly implemented, and then the states have to be consulted more. Along with it, we need to ensure the proper functioning of the Dispute Resolution Committee. Now the Dispute Resolution Committee, which is aimed at resolving the cases before it goes into the tribunal, is a welcome step. But we need to ensure that the states do not see it as an imposition. That's the first thing. Second thing is that the DRC, its function with respect to the noting of the data as well as recording the positions of the different states, these are all kind of similar to that of the initial or the preliminary stages that are being done by a tribunal. So we need to ensure that the DRC is different from this preliminary stage of the tribunals, and it needs to ensure that it gains the credibility as well as trust of the states, so that it finds acceptance from the states itself, and it's not seen as an imposition by the states, and ultimately it going to the tribunals for its adjudication. So DRC has to be made more effective, and it has to be made more participatory and credible among the states. And then the data gathering agency has to be properly functioning, and its member composition has to be properly maintained. It should be the experts, and also we need to ensure that the data is periodically updated. And also there has been increased instances of politicizing the interstate river water disputes. So this has led to numerous violence happening between the different states. So what we need to ensure is that instead of this politicizing, we need to attach the humanitarian dimension of the water disputes, and you need to look into the agrarian crisis. There is a sense of responsibility among the states, and that will ensure that the interstate river water disputes are being amicably solved, and that will also ensure that this doesn't lie as a challenge in the attainment of the objective of cooperative federalism. So these are the main things that is in regard to the Interstate River Water Disputes Amendment Bill of 2017. You need to have an idea about how it is different from the earlier provisions, and also what all are the things what are the positives and the negatives, and also what can ensure its proper functioning. So these are the aspects.